Jerry Mason, Kickin lawyer. So as a lot of you guys that follow me this stuff know, my specialty is DUI defense in the state of Tennessee. And so sometimes a question comes up, as for instance today, I had a client in a certain jurisdiction where the DUI case was weak, and I had managed at the first court level to get the prosecutor to agree to just completely dismiss the DUI, the accompanying traffic charges. Everything was being dismissed except for the implied consent charge. Now, I don't like using charge on implied consent because it's actually a civil penalty. And most states have some version of implied consent. The implied consent, in a nutshell, is that the state of Tennessee has said that if you're going to drive on the roadways, you have impliedly given consent that if a law enforcement officer has probable cause to believe you're under the influence of alcohol or drug, that you have impliedly given consent to a blood or breath sample to determine your blood alcohol content. And so the problem is it doesn't carry any criminal punishment. There's no jail time, nothing like that. It only affects the license. Well, here's the problem. The case may be weak, the DUI may be weak, but the burden of proof and the standard to adjudicate an implied consent charge is different than on the DUI because it is a civil penalty. And it has to be adjudicated at that beginning level. In most courts, it's going to be the general sessions level. Some city courts in Tennessee have jurisdiction to do this also. So but the problem that creates is, let's say the DUI case is weak, but you go ahead and have like a preliminary hearing, which is the last stage of litigation in that first level court, right? And the judge says, yeah, he agrees the DUI is weak, but there's at least probable cause to fight it, right? So it's going to continue to circuit court. Well, now you're fighting the DUI in circuit, but they adjudicate that implied consent in sessions. It doesn't follow the case to the next level court. And so now the judge says, you violated implied consent, I'm taking your license for a year. So now the client loses a license for a year on implied consent, but wait, they're still fighting a DUI now in the next court and could potentially get a conviction on the DUI, which also carries a year suspension on the license. So the long and the short is this. The implied consent, you need a lawyer that really understands the nuances of that, because it is possible that through fighting the case, you still get gigged on the implied consent and lose the driver's license for a year, potentially facing additional suspensions with the DUI later. And so if the lawyer doesn't understand the nuances of that, you can end up getting hit with all of it. The long and the short is sometimes you beat the DUI, but you got to take the hit on the implied consent.